we have Kirk Tousaw is going to do a presentation here. He is a barrister and advocate for law reform. His primary practice areas are medical cannabis, regulatory compliance, criminal defense, and strategic litigation. Ladies and gentlemen, please welcome from Tousaw Law, Mr. Kirk Tousaw.
Thanks very much. Appreciate GreenRush Financial Conference has given me an opportunity to come here and talk about a subject that's very near and dear to my heart. I've been practicing in the area of medical cannabis, mostly defending those that are charged with criminal offenses under the old system, with the Controlled Drugs and Substances Act, for about the last 10 years. I've watched the industry grow from a time here in Vancouver when I virtually knew everybody involved in the dispensary industry to the current scenario where there's a tremendous number of players entering the LP market, as well as it seems like more and more gray market medical cannabis dispensaries opening, at least in Vancouver, every week. It's not often you get the opportunity to speak to such a varied group of people, and I appreciate that opportunity. I've seen people here from virtually every aspect of medical cannabis, from patients all the way right up to investors and companies seeking to enter this sector. I'm going to assume, for the purpose of my remarks today, that because this is a business-oriented conference, most of the people here are already familiar with the general contours of the MMPR, the Marijuana for Medical Purposes regulations. If you are looking to get into the sector and you're not familiar with the essential basics of the system, I do offer full-day seminars where I come to your place of business. I walk you and your management team through the MMPR. I impart to you as much knowledge as I can over the course of that day, so that at least you have a baseline understanding of what the regulatory scheme looks like, what the rules are, so that you can begin to understand whether this is an opportunity that you wish to pursue, and what are the hurdles and challenges in pursuing those opportunities. I'm also not going to discuss the ongoing litigation under the MMAR or the repealed MMAR, the former regulatory scheme. John Conroy, I see, is in the back of the room. I know he's going to have some things to say about that later, and I could possibly do it as well as he will. So I'm going to leave that off to the side. If you have questions about the ongoing litigation, I'm happy to answer them. I think there's going to be an interesting panel later this afternoon as well. What I am going to focus on with my remarks this afternoon are three areas of the MMPR that I believe already cry out for a new regulatory approach or amended regulatory approach. The lens that I'd like to view these issues through is that of patient access. This program, as Terry mentioned just a moment ago, the MMAR program and the MMPR program really at base are designed to ensure, and were birthed out of court decisions requiring that patients, critically and chronically ill Canadians that require or wish to use marijuana for medical purposes, have a reasonable access to that. And that's a right that's grounded in Section 7 of the Charter of Rights and Freedoms, and one that's not going to be going away. I think it's important to, while we cover all the different aspects of the industry, not lose sight of the fact that this exists because sick and suffering citizens of this country and residents of this country need access to this medicine. It's good for them, and it can both help their symptoms, as well as, we're now learning, have potentially curative effects on a whole host of conditions. So patient focus, in my view, absolutely critical, not just for understanding the regulatory approach that should be applied, but also for the success of your business. As in any business, if you're not serving your customer base, and in this case, those are the patients that require access to medical cannabis or wish to use medical cannabis or cannabis-based products, then you're not going to be successful. And so my focus here is to talk about really, I think, three areas in which the regulatory scheme can be amended, either through lobbying or litigation. And those changes will both broaden patient access as well as benefit people in the industry that, after all, want to have a successful company that ends up, at the end of the day, making money and paying your employees and paying your bills and those kinds of things. So I have three general areas I'd like to talk about. The first is, and I think Joy Davies probably talked a bit about sad reality, as we heard in his earlier speech before the break, is that most patients that are currently using cannabis for medical purposes, or at least many, are disabled, on fixed incomes, or seniors. They're living in situations in which they're simply unable, under either the old system or the current system, to afford sufficient quantities of cannabis medicine. It is the provinces, and not Health Canada, that determines which medicines to cover in terms of reimbursement of the cost of the medicines. And so I think that there needs to be a focus put by patients and by licensed producers in this industry on going to the provinces and making the case that cannabis and cannabis-based medicines should be covered under provincial plans like we have with MSP here in British Columbia. It's not a new concept. In fact, I was on the air on the radio on CKNW about 3 years ago with then a very popular radio host and now the Premier of British Columbia, Christy Clark, talking about this issue. And what then radio host Clark said may or may not jive with now what Premier Clark would say, but we closed the discussion and I said to her, look, we need to have the provinces covering the cost of this medicine. People can't afford it. And her response was, if you can prove to me that covering the cost of medical cannabis will save the taxpayer money, then I'm all for it. I'll support it 100%. Well, we know that cannabis can replace many more expensive pharmaceutical medications that are covered. We know that cannabis produces fewer side effects, those side effects often requiring additional prescriptions for pharmaceutical medicines, which then cost the taxpayer more money. And we know that cannabis can have not just symptom-relieving or palliative properties, but in fact, cannabis and cannabis-based medicines can have potential curative effects, which ultimately, of course, would save the taxpayer money because most pharmaceutical substances are there simply to treat symptoms. And with people with chronic lifelong conditions, the more that you can bring them towards a state of health and balance, as Dr. Hornby talked about, the less they're going to cost the taxpayer at the end of the day. So I say the research is in. I think this issue's been proven. And so I say, Premier Clark, it's time to pay up. It's time to make British Columbia a world leader in covering the cost of medicinal cannabis and cannabis-based medicines. I think that achieves really three goals. It achieves the goals of getting patients the medicine that they need. It saves the taxpayers money, and it makes those participants in this emerging industry successful. And that's a win-win-win. And so that's step one in how we can make the existing regulatory scheme a better regulatory scheme for everyone. The second topic area I'd like to touch on is cannabis-based medicines. And what do I mean by that? When I say cannabis-based medicines, I mean those range of medicinal products that are derived from the active ingredients in the cannabis plant. You heard Dr. Hornby talk a little bit about this, and there was a question about the acidic forms of cannabinoids and juicing and those kinds of things. At the end of the day, the medicine that patients need is contained in the trichome glands that grow on cannabis plants, predominantly in the flowering areas of female cannabis plants. The resin, to use the terms of the Controlled Drugs and Substances Act, hashish, to use more slang terms, dry sift, keef, whatever you want to call it. It's those gland heads that contain the cannabinoids, it's those gland heads that contain the terpenes, it's those gland heads that are the medicine. The plant is a delivery vehicle for that medicine. The gland heads are what you want. And you could do a lot of tremendous and interesting things with those gland heads. You could first make concentrated forms of resin. Dry sift, probably, I think, the purest and best example of that. Water extracted resin, also known as bubble hash, extracted with technology like bubble bags that I think Bubble Man is going to be here to talk about a little bit later, or solvent-based extracts, if they can be made with sufficient purity. And then you can take those resin glands and you can make them into tinctures, you can make them into oils, you can make them into foods, you can make them into capsules, You can standardize dosages, you can standardize the amount of THC, CBD, CBN, terpenes, and all of those kinds of things that are a little more difficult to standardize when you're talking about just the flowers themselves. Unfortunately, the MMPR restricts licensed producers and patients from producing and consuming cannabis in any forms other than dried flowers. Don't believe the comments that you may see from Health Canada or elsewhere suggesting that, well, licensed producers of the MMPR can't produce resin or cannabis-based medicines, but patients are perfectly able to do so if they wish to. I think that's problematic from a legal standpoint. If you take the dried flowers that you've purchased lawfully from a licensed producer and you refine that down into cannabis resin, just simple hashish, you take your buds, bounce them on a screen, you've got a little bit of a beautiful dry sieve there, you go out in the public, well, you're no longer in possession of what the MMPR allows you to possess. You're in possession of resin that is unlawful, that can get you arrested. By producing the resin, you violated the Controlled Drugs and Substances Act, and producing resin in the Controlled Drugs and Substances Act carries with it a maximum penalty of 14 years in prison. If you made edibles or topical products, you are now in possession of THC or CBD, a different offense under the Controlled Drugs and Substances Act. It's illegal, and so patients remain just as at risk as they ever were under the MMPR and its arbitrary restriction to dried flowers only. I say it's arbitrary, and that's not my opinion. That's the opinion of the BC Supreme Court. I litigated this issue in a case called R.B. Smith, successfully advocating for the right of patients to consume cannabis in forms other than dried flowers alone. And a judge of the BC Supreme Court said charter rights of patients in British Columbia require access to these other forms and struck the word dried from the MMAR, the old scheme. So why did the government essentially ignore that in promulgating the MMPR? Well, unfortunately, it's part of a pattern of ignoring what the courts have said about charter rights of patients. But it's something that LPs and patients need to be lobbying the government to change. And they need to be doing it because, again, it's a win-win situation. If we provide lawful access to cannabis-based medicines to patients, patients win. And if LPs are entitled to compete with existing gray or black market suppliers of these cannabis-based medicines, then they win. And ultimately, at the end of the day, what we're looking to do is bring all of us out of the darkness and into the light, and to legitimize and make lawful all aspects of the medical cannabis industry, and that includes resins and derivative products. Now, I mentioned a moment ago competition with existing gray market suppliers of medical cannabis. These are compassion clubs or medical cannabis dispensaries, and that's my third topic that I'd like to just briefly touch on today before the red light here goes off and they drag me off stage. Although I think somebody said we were ahead of schedule, so I might run on a little past the red light if that's acceptable. But my third topic is we need to lobby the government or litigate to enshrine the right of dispensaries to continue to exist and to distribute medicine to patients in a retail brick-and-mortar setting. It is unconscionable. And frankly, it makes no sense from a delivery of medicine standpoint to restrict licensed producers to simply producing it and having online or mail order delivery. That puts them at a competitive disadvantage. It's not how we deal with any other medicine in this country or natural health products. If you walk around Vancouver and you want to buy all manner of natural remedies, you go into the store, you look at the quality of the product you're getting, you smell it, you look at it, you talk to the shop owner about it, you can find out where it's sourced from, you can find other patients that have benefited from that particular product, you create social capital in that brick and mortar environment. And dispensaries have been doing this for more than a decade here in Vancouver and across the country. They've been doing it very, very well. They have a ton of institutional knowledge. They have membership bases and lists of patients that are obtaining products from them. And they've done that at tremendous peril to themselves, tremendous legal peril to themselves. And these people are pioneers and heroes. And they've been clamoring for a decade to the government to say, look, we know what we're doing. Bring us into the fold with reasonable regulations that allow patients to have access at a storefront level. This has a number of benefits. For example, persons that living on fixed income, if you've got to mail order your cannabis, you've got to pay shipping charges on every package. Well, nobody's buying a gram of cannabis by mail order and paying $15.95 in shipping and handling charges. It doesn't make sense. But if you talk to dispensary operators, you see that much of their client base scrapes together enough money to buy a gram of medicine a day or every 2 days, comes in, buys that gram, consumes it, gets the relief that they need, and then comes back the next day without any of the hassle and cost and expense of ordering by mail. So how does this turn into a win-win for the industry? It turns into a win-win this way. There's a tremendous number of synergies that exist between licensed producers under the existing scheme and the network of existing retailers, brick-and-mortar retailers that exist throughout Canada. They have clients. Licensed producers need clients. That's an area in which I think there's going to be a tremendous amount of difficulties for licensed producers. They have institutional knowledge. They know what they're doing. They know how to talk about the medicine. You gain social capital. Social capital is what you get when you go and meet with like-minded folks and understand and talk to people about, okay, well, I've got chronic back pain, I've got psoriatic arthritis, you have rheumatoid arthritis, you have AIDS, you have MS. Let's talk about what strains, what medicines, what modes of ingestions, what delivery systems work best for each other, and let's share that knowledge. And oh, by the way, at the same time, we're in a supportive environment where we're helping each other emotionally and psychologically, which itself has benefits to health and to life. These are things you simply can't achieve over the phone or online. It needs the personal touch. By blending the existing network of unlicensed, gray market, brick-and-mortar sales with the emerging industry in licensed, standardized, quality-controlled production of medicine for patients, we achieve, again, another win-win. LPs get clients and distribution sources, dispensaries get legality and the ability to not worry about the police kicking your door down at night and not just arresting you, because these people are willing to take that risk, but interrupting the supply source for your thousands and thousands of patients who come to depend on you for the medicine that they need to improve their quality of life. And the patients benefit by getting high-quality, standardized medicine in a variety of modes of ingestion and in a convenient way to access it. So again, it's win-win-win for all the participants that are concerned. So those are the three areas, I think, that cry out for future regulation, for lobbying, and as I say, potentially for litigation, because if you're a drug company, and you go to Health Canada and you say, well, I'd like to market this drug for this particular purpose in Canada, and they say no, you don't sort of just go quietly away with your tail between your legs. You go to the federal court and you sue for the right to do that if you believe the government has acted arbitrarily. The federal courts are chock full of Eli Lilly versus Minister of Health and all those kinds of things. And I foresee that some LPs, once they get over the hurdle of saying, well, we've got to be the government's best friend or they're not going to give us our license, are going to say, well, wait a minute. Why is it that I can't sell a standardized dosage of a high CBD concentrated resin to my patients? Why is that unlawful? It's better for them, it's better for us, and it's better from an industry perspective. That's the very essence of arbitrariness when you outlaw that kind of conduct. So we need to make those changes. It's absolutely critical for the development of this industry that at least those three changes be made. And I think it's a situation that will benefit everyone, from patients all the way to producers and investors alike. So those are my comments, limited as they are, on what I see as sort of the next steps in the development of this emerging industry. If you need further information, you want to get a hold of me in any way, my website is tousawlaw.ca. It's tousawlaw.ca. Or feel free to just grab me in the hallway and we can have a chat. Thanks again, GreenRush. I really appreciate the opportunity. And thanks to everybody for your attention.